So everybody understands Roe v. Wade was overturned, and we'll go over the reasons why it was overturned and the legal reasons. Because again, this is a hard law piece to it. We're not going to talk about the emotions about it. We're really just going to talk about the legal reasoning behind it, and we're going to judge the legal perspective of it. First, I want to do is that the Supreme Court, there was an issue. John Roberts, Chief Justice, wanted to uphold Roe. And the reason why it took so long to come out is because he was adamant that he was going to keep it in place. He was trying so hard to get one more vote, but just didn't get the vote. So I wanted to play this for you guys, which I think is fascinating.
Unprecedented leak of a draft opinion reversing Roe that may have doomed Roberts' efforts.
New details obtained by CNN reveal the high-stakes internal abortion rights drama that intensified in April when the justices first learned the draft opinion would soon be published. Tensions over the fate of Roe were only heightened by an investigation into the source of the leak that diminished whatever chance Roberts had to dislodge the 5-justice bloc set to overturn the abortion rule.
Joining us to share her fascinating new reporting here is CNN legal analyst Joan Biskupic. Joan, tell us how hard he was fighting to bring some folks over to his side.
Morning, Brianna and John. Extremely hard. He was trying week after week after the initial vote in December, after oral arguments, in which 5 of the justices on the far right voted to overturn Roe. Roberts was alone in the middle, wanting to uphold this Mississippi 15-week ban on abortions, but not go further than Roe. And then, of course, you had the 3 liberals saying, we don't want to do any of this. We don't want to disrupt abortion rights at all. So Roberts keeps trying. And it's interesting, Brianna, that not only did his work affect, his efforts toward the 2 newest justices, Brett Kavanaugh and Amy Coney Barrett, but it had an effect on the others. The hard right justices became concerned that he could be successful. The chief has himself switched votes in the past, and he has also been able to pick off justices on the far conservative side.
What I think is the most interesting is that you had 5 justices who wanted to overturn Roe. And the Chief Justice, in the middle there, he said, well, I want to keep the foundations of Roe, but I want to move the whole viability thing. Let's move it back. So he wanted to uphold the law. And I think the other 3 Democrats or the other 3 liberals on the court would have also accepted that piece of it if they could have got one more conservative. But the conservatives really held firm and said, no, this is going to be overturned. Now, there's been a lot of confusion on why or how they were able to overturn it. And you'll hear it through all the commentary, right? You'll hear all the commentary always talks about tradition. They said it's not tradition. It's not tradition. So let me explain to you exactly why Roe was overturned in the way it was. Now, I have a video on it that explains it too, but I want to make it very clear why Roe was overturned and why I'm assuming that eventually when you get the court with the different makeup, it's going to be put back in place. So what I'm going to show to you on the screen now is known as the Palco Test. Now, this test from this case is used when the Supreme Court decides, hey, we want to see if there's a right out there that's fundamental, and we just don't know if the right is fundamental or not. But how do we know? How do we know if there's a protected constitutional right out there that wasn't listed in the Constitution? Well, this is a test that they go for to do it. And abortion was one of those rights that wasn't listed in the Constitution that the court in Roe versus Wade said passed this particular test, the Palco Test, to qualify as a protected constitutional right. Let's look at the test real quick. The test for Palco is simply either the principle or the right is so rooted in the tradition and conscience of our people, American people, that it is to be ranked as fundamental. So you look at it from a historical perspective. Or now it could pass that and be good. You got a constitutional right if it passes number 1. Or if it doesn't pass number 1, you look at the or number 2. It's implicit in our concept of the order of liberty. It simply means that you need to exercise this right to exercise a right already in the Constitution. And an example I like to put of this is your right against unlawful search and seizure, unreasonable search and seizure. So naturally, the government can't search your stuff without a warrant, and that warrant has to be based on reasonableness. Well, the warrant itself has to be based on probable cause, but it has to be reasonable. Your protection is against unreasonable search and seizures. But in that protection against police being able to search your stuff, there's an inherent right to privacy, right? You have a right to privacy within your effects, and that right to privacy can only be overcome through the warrant process. So the court it's a case called Katz v. New York, but in Katz, the court said you have a right to not only a Fourth Amendment right against unreasonable search and seizures, but implicit in that right against government intrusion into your stuff, unreasonable search and seizures, you have an implicit right to privacy, right? And the government can only violate that right to privacy through the same process as getting a warrant. I probably messed that up and made that so confusing, but that's essentially what it is. I need to exercise this right to exercise the right in the Constitution. Now, some people were saying that Roe did not address number. The court in Roe just said, okay, it's in the First Amendment, Second Amendment, Third. They listed a whole bunch of rights, but didn't attach it to any one of them. So number 2 can be totally overlooked. So we're really looking at number 1. And was the principle rooted in traditions and science? So now I want to do something. I'm going to give you guys the legal arguments that are now working their way in academic circles on why Roe, or the right to abortion, should be upheld. So the conservative court now has said, well, the right to an abortion is not deeply rooted in our traditions, right? And they go back and say, well, when Roe was decided, most states had it illegal. If you go back to the beginning of the Republic, there was always something about it. It looked in common law. He said, yeah, this is never a right. It's not tradition. We're done. All right. That's what they said. But on the second piece of it, they said, well, since it's not tradition and it doesn't pass the Palco test, it's done. We're done. We're not going to keep a right that we can't justify. That's what the conservatives in the court said. We're not going to keep a right that we can't justify based on this traditions. Now, the liberal justices, they make a counter argument to that. And their counter argument is that the conservatives are looking at traditions in an incorrect manner. Tradition isn't what we did back in the 1800s. Tradition isn't what we did back in the 1700s. Traditions are what people are living through now. So they counter and say that every woman alive today has spent the last 50 years of her life with the constitutional right to end her pregnancy. And now, 50 years later, that right is just gone. So do we look at the 50 years that we've had this constitutional right? Does that apply to tradition, right? Something that we've been doing for 50 years? Does that tradition seems to be ignored? But do we look at tradition from 200 years ago, or do we look at tradition from just, recent tradition, 50 years, 100 years, 75 years ago? So the academic quandary here is when we talk about tradition, whose tradition are we talking about? And you can definitely see the pushback from each side. One side is saying, well, they wrote the document in 1700, 1800s, right? So that's what we were talking about, what, they thought back then. And then you have another side that says, yeah, but back then, we didn't have cars. We didn't have planes. There were certain things that they could have never suspected. The ease and access of abortion now, right? So the law should be written for the people and the people alive today, right? We live in a totally different world than we did 100 years ago, 200 years ago. So the left is saying tradition should be kind of codified in this, in the relevant time period, where everyone alive today, what traditions have we lived in? So do we look further back? Or do we look at a concurrent state of mind? So that's the legal effort. And I'm assuming when you get 5 liberals on a court, they're going to take the tradition argument and say 50 years of this being the law is tradition enough to surpass the first prong of the Palco test, right? 50 years of it being the law of the land, 50 years of it itself makes that tradition. And I think when the conservative justices are going to say that 50 years of tradition is not enough. It was not enough to keep Roe in place when it first got into place. And now you can't use that to make it a constitutional right because, it was kind of fraudulently put into place at the beginning. I think we're going to get back to a place where it's going to be, Roe is going to be reinstated. Eventually, we're going to get enough liberals on the court that says this is a right that needs to be inside there, right? And when that happens, we're going to be in the opposite place. So I think right now people are scared, people are worried. But the legal reasoning behind both is what it is. So now, if you agree with the legal premises, I want to make it very clear: the fight now for Roe is what does tradition mean? Does it mean 1800s, 1700s, early 1900s, or does it mean the last 50 years? That's the fight. That's the academic fight. And in both ways, if you get 5 justices who are liberal, they're going to say the last 50 years. If you get 5 justices who are conservative, they're going to say it goes farther back than that. Here's a list of some other unwritten rights that the court has found. 1958, the right to travel. 1925, the right. Did you guys know you had a constitutional right to homeschool your children? In Maynard v. Hell, the right to marry was found to be fundamental. Also in Skinner v. Oklahoma, the right to have children, because I think that case was the government was doing two things. It was forcing people to be sterilized. So they were like, well, you have a fundamental right, a constitutional right to have children. You have the right to teach your children other languages. That's another constitutional right in Myers v. Nebraska. Lochner v. New York. This is now, if you're a law buff, we all have heard of Lochner. Lochner is if you Google the ghost of Lochner, and you'll see it's the right to contract. And it was one of those times where the court just kind of made up a new right of the whole cloth. And I think people started seeing the true power of the Supreme Court, because think about it. If the Supreme Court is able to say, hey, here's a new right, give new rights, that's insane. That's insane. So yeah, so Lochner v. New York was right to contract, and you'll see the ghost of Lochner, because it's a interesting decision, but it's given the Supreme Court a lot of problems. Moore v. City of Chicago, you have a constitutional right that your extended family share your home. You also have a constitutional right to have competent adults to refuse life-saving medical procedures. So these are all the unwritten rights that most people don't even realize they have. But the Supreme Court has been looking through them and saying, yeah, we have, the Supreme Court has been going through all these cases saying you have a fundamental right to this, you have a fundamental right to this, you have a fundamental right to this. And these are constitutionally protected rights. So there's a whole bunch of them.